I'm Kiara Hay, but we're going to start with our breaking news on a truly heartbreaking death of a 5-year-old boy. He was killed this morning when a hyperbaric chamber exploded at a medical facility in Troy. Police just explained how this tragedy happened. So for the latest, we're going to go live to Troy with 7 News Detroit reporter Randy Wimbley. Randy, what can you tell us?
Yeah, Kiera, an absolutely tragic situation here in Troy. As you mentioned, the 5-year-old boy died after an explosion inside of a hyperbaric chamber. His mother, who was in the room, was also injured. I want to have you guys take a look. This is the building in question. As you can see, still a bit of an active scene here. This happened at the Oxford Center on Kurtz Boulevard. That's near 75 and Big Beaver, just before 8 o'clock this morning. Now, the center uses those chambers for hyperbaric oxygen therapy for children with autism. And here's how that works. By having them breathe 100% oxygen while in a pressurized chamber, it increases the amount of oxygen in the patient's blood. But here's the problem. The Troy Fire Department says that having that much oxygen in a pressurized environment can make it extremely combustible.
Upon arrival, the first arriving units unfortunately discovered a 5-year-old boy deceased on the scene.
We did some initial investigation. This is very uncommon, so we're not sure what led up to it, and that's what our investigation is going to show. So in further time, we'll be able to release that information, what exactly happened with that chamber.
Exceptionally difficult day for all of us as law enforcement officials have shared at our location in Troy. This morning, a fire started inside of a hyperbaric oxygen chamber. The child being treated in that chamber did not survive, and the child's mother was injured. The safety and well-being of the children we serve is our highest priority. Nothing like this has happened in our more than 15 years of providing this type of therapy. The center went on to say that we do not know why or how this happened and will participate in all of the investigations that now need to take place. If you are just joining us, a 5-year-old boy died after an explosion inside of a hyperbaric chamber at the Oxford Center here in Troy. We're going to have more information from the police department and the Troy Fire Department at 5 and 6 o'clock tonight. But for now, we're live in Troy. I'm Randy Wimbley, 7 News Detroit.
This case is of great concern for public safety. If this is how this operation is being run, I'm so relieved that this hasn't happened before.
And something the Troy judge repeated several times could have been prevented. But the Attorney General's office alleges the Oxford Center CEO, Tammy Peterson, and 3 of her workers put greed over patient safety, leading to second-degree murder charges and involuntary manslaughter for Alita Moffitt. In court, we learned she was the unlicensed worker running the hyperbaric oxygen chamber when it caught fire, killing 5-year-old Thomas Cooper.
One of the co-defendants in this case was actively tampering with this particular hyperbaric chamber, and all of the evidence leads us to the conclusion that it was done with the permission and perhaps at the order of this defendant.
The prosecution believes Peterson encouraged her assistant manager, Gary Markin, to alter the machines, rolling back thousands of cycle hours to avoid required maintenance of the hyperbaric chambers. Her safety officer, Jeffrey Mosteller, is accused of not following safety protocols. Both also charged with second-degree murder after investigators discovered the day Cooper was killed, there was a lack of grounding wires, creating a spark that triggered an explosion. Flames erupted in the chamber, and Thomas, who was receiving treatment for ADHD and sleep apnea, was trapped inside.
The investigation into this tragedy has revealed how the Oxford Center in Troy and several of its key decision makers held safety among their lowest considerations in their hyperbaric treatment practice.
We've learned the Oxford Center was understaffed and undertrained. The day of the explosion, one worker didn't even know how to work the fire extinguisher. When police started investigating, the Assistant Attorney General claims Peterson immediately wiped her laptop, lied, and ran from police who wanted to search her phone.
Days after the explosion, the defendant admitted to wiping her laptop. She lied to investigators to prevent access to video of the explosion in this case.
The judge in this case considering Peterson a flight risk after it was revealed she had an active visa to China and recently purchased Iraqi currency.
What I'm going to do at this point in time is set her bond amount of $2 million.
The judge also forbid Peterson from going to or talking to anyone at the Oxford centers in Troy or Brighton, since we've learned she has a history of harassing and using legal pressure to silence those who speak out against her. Markand and Mosteller had bonds set at $250,000. Moffitt set at $100,000. Defense attorneys in this case vowing to fight.
We believe in the system of justice. We're going to fight this case. Oh, yeah. We think that there's going to be a lot of issues, a lot of problems with this case.
We saw the press conference earlier today, and they put out there for the world to hear that they know exactly how this fire started. Show me the money.
What's most concerning for Attorney General Dana Nessel is this cash-only oxygen therapy using hyperbaric chambers isn't regulated and doesn't require state oversight. The machine that exploded, according to investigators, did not have a fire suppression system.
Because they were not maintained properly, that those defendants involved should have known that there, was a chance, a reasonable chance that we would see this kind of outcome.
Now, those suspects will all be in court again at the end of the month. Michan Feigerlaw is representing the family of Thomas Cooper and are pursuing a civil lawsuit against those responsible for his tragic death.
This is the people of the state of Michigan versus Tamala Peterson.
Thank you. Good morning, Your Honor. Assistant Attorney General Chris Kessel for the people.
Jared Gleason on behalf of Ms. Peterson, who's to my left here. Thank you.
Could you please stand and state your name? Tamala Peterson. Thank you. Are you still using the same mailing address that we have for you on the court file? Yes. Thank you. You can be seated. Today is the date and time that we have scheduled the state's motion. This was a motion that was filed previously entitled Motion for Court Approval of Review Team Process. I did have an opportunity to review a response that was timely filed by the defense. And in addition, after the last court date, the people were able to provide Exhibit A, which had not been attached to the original motion, but the court found it quite necessary to include it. So we received that shortly after the last time we were together for court, and I've had a chance to review that as well. I know that because that was filed after the fact, the defense was provided an opportunity if they wanted to supplement their response. And it's my understanding that no additional response was provided. You intend to rely on your original response?
Yes, sure.
Okay. Both of you can place any argument that you like on the record. If there's anything else you would like to add or focus on that you had outlined in your original written motion and response.
Judge, I think I will just briefly.
Okay.
Thank you. Judge, what we have here is sort of an odd situation where I think we're all in agreement that the defendant has rights that need to be protected. And the people's position is that our review team policy does protect those rights. I know we're all on the same page, now, no pun intended in the document. But what we have here is a policy that gives the defendant adequate protections, but still allows this process to go forward. What we have is a policy where search terms are created by both the defense and the government. And unfortunately, the court does have to do some refereeing here. If search terms cannot be agreed upon, then the court, kind of has to step in. Our third party vendor, which is called KL Discovery, which is not something that was included in the brief, they're the ones who do the search. And they're the ones who essentially control these documents and find any of the search terms that were either agreed upon by the parties or ordered by the court. And ultimately, Judge, what we have here is a process where the defense is getting the first initial opportunity to determine if there's any potentially privileged information that should not be going to the government. And it's only after they make that determination that our review team has a chance to look at those materials. And if there is any disagreement, then ultimately our office, the review team, would file a motion with this court. And this court will be the one that decides the legal question of whether or not a document is privileged. What this isn't, Judge, and I think it's a weird way, but the way to look at how this policy protects the defendant's rights is to talk about what it doesn't do. I'm expounding on sort of something that was in our brief. Is what this document doesn't do, as I said, is give the government the first opportunity to determine privilege. It's not a policy or a process where the government's review team can sort of unilaterally give materials to the investigative team without the defendant having an opportunity to object, or have a say-so. It's not a policy where the government can ignore the defendant's objections. And it's not a policy or a process where the government is performing this judicial function, which is outlined in, I forget my name right, the In Re search warrant case out of the Fourth Circuit. There, the court was concerned that the government's review team was performing a judicial function, answering questions of law. In this case, Judge, in our policy, the government's not doing that, because ultimately, if there is any dispute regarding the question of law as to whether a document is privileged or not, this court would be answering that question, not the people. So the people's position is that this policy does adequately protect the defendant's rights, by any legal metric, by the case law that I think we're both citing. The only thing I would add also, Judge, is Mr. Gleason and I are kind of on the same page in that there's no statute, and there doesn't appear to be any case law, state or federal, that mandates that taint teams must be used. But what I will say, Judge, is that during the Flint water investigation, just like in this case, the government's team had luckily not as much as in this case, but a tremendous amount of electronic material. And when we had that material in our possession, the defendants claimed that some of the material may be privileged. And Judge Kelly of the Seventh Circuit Court ordered that a taint team be used, almost exactly to the one that the people are proposing. And an appeal was made to the Court of Appeals. The Court of Appeals denied leave, saying that there was nothing we need to look at with respect to Judge Kelly's order that a taint team be used. That decision was appealed to the Michigan Supreme Court, and the Michigan Supreme Court, again, denied the application for leave. So I know there's no statute or case that directly says that taint teams must be used or how they should be used, but it's very clear that in that instance, Judge, in a case very similar to this, as far as the materials we're talking about and the privilege concerns that have been raised, that at least one panel of the Court of Appeals and the Michigan Supreme Court has no problem with a circuit court, or in this case, a district court, ordering that a taint team be used. So I think it's clear that in the state of Michigan, this kind of process can go forward without, trampling the defendant's rights. I'm sure I'll have a little bit in rebuttal for whatever Mr. Gleason says, Judge, but unless the court has any questions, I'm happy to have a seat.
No, that's great. Thank you.
Thank you.
Your Honor, I think we are in agreement that the attorney-client privilege is a cornerstone in state's jurisprudence. It is something that you, before you took the bench, exercise with your clients. I do it every day with mine, and it is there for reason, and it has been there for time immemorial in terms of what attorneys, how they communicate with their clients, and how the clients communicate with the attorneys. The Troy Police Department was notified on February 5th that items that they seized contained potentially privileged communications between Ms. Peterson and her attorneys, not just me or Mr. Cranmer, but other lawyers and other law firms. It appears that despite that, the Troy Police Department examined those laptops and Ms. Peterson's cell phone, because if the court looks at page 17 of the swear to, Detective Trigger indicated to the magistrate that in fact, further review of the cellular devices and laptops pursuant to the search warrant showed investigators' messages. So they've already looked at them. And this motion comes a little late in that regard because the police department already did it. And that's a problem. Mr. Kessel also used that information to argue for bond that same day, indicating that information had been found, and these are reasons to detain Ms. Peterson. The use of a taint team, I submit to you, is a usurpation of the judicial function. The lawyers don't get to determine in an adversarial case what is privileged and what is not. You do, judges do. The executive branch does not get to review my communications to determine whether they're privileged or not. The proposed taint team are assistant attorney generals. Those are people hired by Dana Nessel, paid by Dana Nessel, sometimes promoted by Dana Nessel, but they're in her office. It's the same office. This isn't some independent group. It's the Attorney General's office. And that's not the judicial branch. And yes, I agree that creates perhaps more work for the court, but that's why we have courts, to make these calls as to what's privileged and not the prosecutor. If this were a civil case, would the plaintiff get to decide what communications are privileged for the defendant or vice versa? Absolutely not. There's no difference here because it's a criminal case, and I think even more so here, because in a criminal case, one side has a tremendous amount of power, the government. The government has search warrants, administrative subpoenas, arrest powers, none of which the defendant has. And in these scenarios, far more than even than in a civil case, the judiciary is the one that says to the executive branch, you've gone too far. We come to you with search warrants and say, Judge, you need to decide whether this violates the Fourth Amendment. We come to you to decide whether an interview has violated Miranda and the Fifth Amendment. We come to you to decide whether due process has been violated. We don't go to the taint team at the Attorney General's office to make that decision because we're the judge. And that's what the people in the state of Michigan and in this district are elected you to do. The Flint water case I submit is a misnomer because, as I recall, that case kind of fell apart for the Attorney General. And so it was never reviewed upon a conviction. It was interlocutory. And I have yet to have the Court of Appeals in any of my cases decide anything for a criminal defendant interlocutory. They wait till the conviction enters and then decide the case. So I think that's kind of, to say they declined to hear it mid-case isn't authoritative. The policy that I got, the court received afterwards, it doesn't exactly work like Mr. Kessel is representing, I don't think. It's not as if this vendor, KL, whatever, gives everything to us to review before the Attorney General's office sees it. That's not what happens. In subparagraph K, there's a privilege team, that's assistant attorney generals, that makes it determine whether it's privilege withhold, privilege redact, privilege exception, and not privileged. That's the Attorney General making that determination, not me. And then when you look further on, it's subparagraph 01 through 03. The Attorney General's office, the taint team, can turn over whatever it wants, whatever it decides is not privileged. The only stuff, as I read this, that we get to see is when the taint team says, oh, maybe this is privileged, or oh, this is privileged. The stuff that the taint team decides is not privileged goes immediately to the investigative team before I even see it. So not only do we have the executive taking your power away from you, which should not happen, we also have a policy here that's designed that all this takes place before we ever get to see anything. It's not as if they give us all of the material and say, this is what. They only give us a small slice. What they find is not privileged, they turn over. And we have nothing, we have no way to deal with that. So that's.
Wait a minute here.
Sure.
Can you please go to the top of page 8 of 9 under section O, which you just referenced?
Yes, Your Honor.
So section O is specifically outlining the handling of potentially privileged materials designated as not privileged. And you just argued, which is important because in some of the case law that was reviewed, this was really a deciding factor when you have material that's reviewed and a team that has been developed and serves as the filter team or the taint team or whatever language you want to use, makes the decision in the other cases that certain materials are not privileged and they just turn them right over to the investigative team. That was problematic for one court. And I reviewed Exhibit A and noted under every section, including the section where the materials have been determined to be not privileged, there's still a component that requires that all of that material has to go over to the target or the target's counsel, and a reasonable opportunity must be provided to review and either agree with or object to the review team's designation. And if there's not an agreement after that occurs, comes back to the court. So I see this as even the material that's determined to be not privileged still goes to you and to Ms. Peterson for review before anybody gets it.
I don't read it that way, Your Honor. The court looks, the review, the categories that the taint team creates is subparagraph K. Privilege withhold, which is supposed to be, I think, the term is privilege redact, privileged exception, and not privileged. In paragraph 03, the privileged team may turn over not privileged material to the investigative team. So under K1D, the privileged taint team, whatever you want to call it, filter team, if they find in their determination, not ours, they can turn it over under 03.
After 1 and 2.
No, because 1 only requires the potentially privileged material to be turned over.
Well, and I'm going to let you continue, and I'm sure it's not welcome that I'm interrupting what you have an opportunity to say at this point, but this is important to me. So I want to make sure that I understand this, but I also very politely want to point out that this is part of the reason that I had asked if you wanted to supplement your response after we actually got this document, because part of what I'm sure we'll get to here in a moment is that there is case law that specifically addresses the use of a filter team or a taint team. And a lot of the decisions that I saw have been made by the U.S. Court of Appeals really hung on language here. And so this is something that I think we want to all make sure we're on the same page.
Understood. I thought it was clear, because here's what I'm seeing in 01 is that the privileged review team sends it to me. So the privileged review team already has it, has already made its decisions among those 4 categories. And that's what the cases that I cited you was the problem. Because the defense attorney is second in line. And again, I'm moving past my judicial function argument, but the concept here is, and I think the cases that I cited is the box in the hen house and what we read there. Here, the privileged review team has the stuff first, and that's the distinction. And that's why I read it pretty clear, because it's not KL, the vendor, sending it to us for us to do our review. KL sends it to the privileged review team at the AG's office, and that's the problem. And that's how I read that. And Mr. Kessel wants to say to me I'm wrong, that's fine, but it's the plain reading of the policy. And I think he has to, if you ask him, he has to answer, yes. We send the electronic devices out to KL, we give them search terms, then it comes back to our privileged taint team in our office. And from there, it comes to us. And that's the problem with the policy. And I think that's the overall problem with all of these filter teams. Again, it's injecting the executive branch of government where the judiciary should be making that initial decision.
Okay.
And again, I don't think, in a civil case, if I were to get interrogatories or requests for documents, I, the attorney for the party, would do the review. I would create a privilege law. I would send it to the other side. And if they disagreed, they would come to you. They wouldn't say, I want to see those. I mean, that's the whole purpose of the court reviewing privilege. So that's why I'm thinking here that the policy doesn't work. It really doesn't work just because of this idea that you make the decision.
Okay. So I don't think what you're saying then is that initially it appeared as though you were indicating that at some point in this policy, when some determination has been made about a subset of the material, there's an automatic right for the privilege team to just release it to the investigative team. I disagree with that. I think your bigger issue is that, your bigger issue really is there should just be no filter team. That's what you're saying.
Correct.
Okay.
If there's a vendor KL, those documents, it's pretty much emails, right? That's what we're talking about, communication, attorney-client privilege. Those emails should come to you. I can't imagine there's tens of thousands of them.
So where was the case law that supports your position?
The case law that supports my position, Your Honor, I cited in my brief.
Well, the case law that was cited, from the court's perspective, really it was really 3 cases that both of you utilized and took different bits of information and different parts of the opinion to support your position. But if your overall position is the law does not support the use of a filter team, period, in a criminal case, where is it?
I believe that's the standard, the fact that the judiciary, because I don't think there is a Michigan case, right? I don't believe there is. And we cited federal cases, In the U.S. Attorney's Office, I will concede federal prosecutors can continue to use tainting. And I'm arguing under the Michigan Constitution as much as the federal. This is a judicial function.
I 100% agree with that. So that isn't something that you have to convince me of.
Right.
But ultimately, the process in which the court maintains its judicial function seems to be what is up for debate, I think, at this point.
Here's, if I may, Your Honor.
Yes, of course.
The use of a vendor, the vendor is going to get used no matter what. Someone is going to go and figure out where the Barnum or Miller Canfield emails with Ms. Peterson. The question is, in my mind, who gets to review those first? And I think if we're going to use a taint team, or if we're going to use something, we get to review them first because it's her privilege. And this policy doesn't allow that. The only thing they give us are the potentially privileged materials.
I think the notion that's a little bit difficult for everybody to wrap their head around is the court's not being asked to pick between Mr. Kessel or Mr. Gleason to review the potentially privileged documents, because I couldn't. I couldn't pick one of you over the other.
Right.
That would simply be unfair. I think what we're struggling with is the notion that the proposed filtered team is comprised of attorneys that work for the Attorney General's office. But I think it would be a little bit unfair to say that the proposed policy as it's been presented to us doesn't make, I think, it very clear that it's not to be anybody that is a part of the team that is working on this case. Yes, there are going to be employees or attorneys of the Attorney General's office that would be identified and would serve on the filter team if the court approves it. But I feel like, for argument's sake, there's an attempt to appeal to the general sense that the court would approve a filter team like this, and I'm essentially letting the Attorney General, Mr. Kessel, make the decision on privilege. But I think it's really a little bit more nuanced than that. I need to see a policy, a proposed policy or protocol that clearly identifies, to the extent that it can, that anyone that would be involved in this process after the vendor culls all of the discovery and gives whatever falls under gives the discovery that falls under the parameters with the search terms, and they review it, but they would be separate from your side or Mr. Kessel, really. So I think I really would like to hear Mr. Kessel probably focus a little bit more on that, just so we can have a record. And I understand your position very, very clearly. But I just think in general, I want to hear Mr. Kessel argue to the extent that he can, what's in the proposed protocol that is identifying a separate and distinct body that would review the information that comes from the vendor, and make it very clear to the court, if he wants me to consider what's proposed, that it will be not one single person that is involved in this case, or is working on this case, or has worked on this case, or may work on this case, because I think that is the key component here. And I worry that when the argument really centers around, well, Judge, you're just going to give it to the AG's office to review everything and make the decision. I just want the record to be very clear that it wouldn't be just turning it over to Mr. Kessel to review everything. My expectation is it is a completely separate and distinct body of attorneys that would be doing that. And the defense hasn't proposed anything that I could consider from their end with a separate and distinct set of attorneys.
I proposed to special master or the court to just review those emails that are determined to have come from Barnum and Miller Canfield. My view is if we're going to allow a privilege examination to occur, it doesn't involve the defense counsel or the prosecuting attorneys. It should be someone who is neutral, impartial, and uninvolved with the process. And my view of the world, and I have the utmost respect for Mr. Kessel, but the decision you're making here, because we don't have one in the state of Michigan, really, isn't just going to apply in this case. This is something the court looks at in terms of every prosecutor's office, the attorney general, county by county. And to me at least, the review of what's privileged or not, the first person who should decide whether to raise privilege, because there are certain instances like advice of counsel where you might not raise it. But that initial decision should be made by the holder of the privilege. I think that's what my argument is.
Okay,
Thank you.
thank you.
Judge, I think maybe the better focus might be looking at section H sub 1 sub A, which is on page 4, where after the search terms are agreed upon, and again, that's something that Mr. Gleason and quite frankly, the review team in my office is going to hash out. I'm not even a part of that. And again, if we cannot agree on search terms, then again, unfortunately, this court would have to kind of come in and play referee. But once this court orders those search terms are put in place, those are the terms that will be used to look through, like I said, sort of control F these documents. And what the policy says is that materials over which the target or target's counsel claims are potentially privileged material, that means anything that hit, right? So any document that contains any of the search terms that either we agree upon or this court orders, those are potentially privileged documents. Anything that hits as potentially privileged goes to counsel. And material over which the target or the target's counsel do not claim the privilege or are not potentially privileged may be turned over to the investigative team. So anything that does not include any of these search terms, yes, that goes to the investigative team, not because we decided it or not because the counsel decided it. It's because those documents simply did not include any of the terms that ultimately this court may have to decide may include some privileged material. Once there are potentially privileged materials, i.e. anything that hits on any of the search terms, counsel gets that, right? And at that point, in court, Judge, this court makes rulings of law on argument all the time. The government will come in, whether it's the city attorney, the Oakland County prosecutor's office, my office, we come in and we say, hey, Judge, this search was legal and here's our position, or this questioning was legal and here's our position. And defense counsel, whoever it is, comes in and they take a position. And ultimately, this court decides the question of law as to whether or not a search was valid, a statement was good, rights were violated or not. And that's all that's happening in this case is the review team in my office and counsel review this set of potentially privileged materials. And in most cases, I imagine there probably will be a lot of agreement on things. Where there's disagreement, my office's review team takes a position, defense team takes a position, and nothing happens until this court orders it. So I think that's the step that this court recognizes, and I think Mr. Gleason is kind of skipping over, is nothing that is potentially privileged goes to me without either a stipulation with Mr. Gleason and my review team or this court's order. Nothing goes to us that they claim is privileged until you order it, Judge. And then as you correctly pointed out, that's the difference between our policy and the policies that were in these cases, right? In the Fourth Circuit case, the government review team said, okay, well, we'll look at everything and we'll decide if privilege applies. And before the defense has a chance to raise an objection or claim a privilege, we're just going to give it over to our investigative team. And, the Fourth Circuit rightly said, no, you can't do that. You're not the arbiter of privilege, right? Because in that instance, the prosecutor's office is performing a judicial function. The prosecutor is not just taking a position on the law, but is really making a ruling on the law as to whether or not privilege applies, and then immediately giving the documents to the investigative team. Obviously, that's not what's happening here. So the fact that my office will argue that something might not be privileged doesn't mean we're performing a judicial function any more than it does a prosecutor's office taking a position on any other question of law. We would have an argument, Mr. Gleason would have an argument, and this court would be performing that judicial function, answering the question of law. Judge, as it relates to that other case, in re grand jury subpoena, the Sixth Circuit case, again, we have a government policy that is very different from the one that we are proposing, in the sense that in those cases, in that case, the government was proposing, we will do the initial review. We will decide what's privileged, and we will be sending our things to the investigative team. Again, Judge, that is not what's happening here. And in fact, the defense in that instance proposed a policy very similar to what we're proposing, which was that a separate party perform a search. The search terms that are agreed upon or court ordered, anything that hit would be given to defense counsel. Defense counsel looks at things. Defense counsel lets the prosecution know what their position is. Prosecution takes a position, and any conflict would be decided by the court, which is exactly what people are proposing here. And Judge, what I would say is I would add, and I think the problem is, and Judge, I think you kind of noted, Mr. Gleason's position seems to be that, taint teams are unfair and unreasonable as a blanket rule. And Judge A, we know that's not true by the case law, right? But also conflict walls exist all over the place, Judge. I'm sure there are plenty of conflict walls in Mr. Gleason's firm. Lord knows there are a million in my office as well. We get emails about them all the time. Conflict walls are a regular part of doing business in the legal world. That's just how it is. And Judge, to that point, what the Sixth Circuit said regarding the taint team, and I'm quoting here, government taint teams seem to be used primarily in limited exigent circumstances in which government officials have already obtained the physical control of potentially privileged documents through the exercise of a search warrant, which is, of course, what happened here. Continuing in my quote, in such cases, the potentially privileged documents are already in the government's possession, and so the use of the taint team to sift the wheat from the chaff constitutes an action respectful of, rather than injurious to the protection of privilege. So there we have, Judge, the Sixth Circuit saying that in instances where the government is already in possession of electronic material, just like in this case, the process of a taint team is not only completely legitimate, but also recognizes and protects the defendant's attorney-client privilege, which again, I think we all agree is of paramount importance, Judge. When the court talked about the government's proposal, which was sort of like what Mr. Gleason's saying was problematic, the court said that the problem is that appellant's attorneys would only have an opportunity to assert privilege only over those documents that taint team has identified as being potentially privileged. But Judge, again, that's not what's happening here. The search terms that are either agreed upon or are court ordered, that's going to be the determining factor as to what documents are potentially privileged or not. It's not someone in my office or someone in Mr. Gleason's office. It's these terms that determine privilege. And then once something is potentially privileged, anything that hits is the universe of potentially privileged stuff. That's when, if there are disagreements, this court has to step in. The court's absolutely right. I have nothing to do with it. I haven't seen any of these materials. I get what comes to me after either our review team and Mr. Gleason agree, or after this court orders any. So I hope I've kind of answered the court's questions, and I know seems like some confusion about how this process works. So unless the court.
No, I'm familiar. I just want the record to reflect.
Absolutely, Judge.
Right, but I think it's appropriate for any case, but also in a case where there's a lot of attention that's being paid. I don't want there to be lack of explanation on the determination that is being requested as to who will review these potentially privileged documents. It's not just as black and white as the defense or the prosecution. And so that's what I was just asking you to speak to, but I think I understand the process, and I've spent quite a bit of time reviewing the case law that I think applies here. So thank you for placing that on the record. Was there anything else? I did see Mr. Gleason looking like he wanted to respond. I'm not sure how appropriate that is, but I will give you an opportunity just to weigh in on anything that was added to the record from the last argument.
Yes, Your Honor. And the cases that we cite about the filter team from the federal jurisdictions, they use the grand jury process And so those are filter teams that are pre-charged looking at documents, where you may get documents from a witness or whomever, and maybe there's no adversarial system in effect there. Here, the case is already rolling. So we have an adversarial system. And if Mr. Kessel is correct that I get the documents first, why do we need a team at all? Because I can say, Mr. Kessel, I believe documents A, B, C, D are privileged. Let's take them to the judge and she can decide. Why do they get to look at them at all? I don't understand why they get a chance to see that when it's you who decide when we say it's privileged. I mean, I go back to my civil law analysis because adversarial cases are adversarial cases. And if there was a plaintiff here and a defendant here, and the defendant said, I have privileged documents, you're not going to say to the plaintiff, okay, wall off part of your law firm and take a look at it. You're going to say, show me the documents and I'll make the call. That's all we're asking you to do here is if in fact I am going to get those documents, I can say they're privileged, I can send them to you, you can look at them, you can either agree or disagree. But they don't get to take a peek. They don't get to do that in the civil context, and they shouldn't get to do that here. Because I'm hearing Mr. Kessel say, I get them first, but why did they get them at all?
Well, that would be the first that I'm hearing about anything related to how they obtained these documents. And this was something else that I really paid close attention to in reviewing the case law. There is a distinction in the way the courts are ruling, and they specifically look at who has the documents. The people have the documents already. And it's my understanding that they've obtained the documents as a result of a properly executed search warrant. So that's not, you can't debate that right now because that's not part of this motion. If that was part of the motion or the argument that was going to be made, this would be a whole different conversation. But when I get the motion that I've received and the response that I have received, there's no indication that we are arguing the validity of the search warrant at this point.
I agree, that's a different issue.
Okay, so I don't want to go there. Obviously, it sounds like you don't either, which is good. But I do think there's a distinction in the way the law is applied in these cases because the government has these documents. I'm not making a determination right now that Ms. Peterson has all the documents and I'm forcing her to turn them over to the Attorney General's office. They have them and they obtained them through what appears to be a properly executed search warrant.
An unchallenged at this point in time search warrant, I guess.
Okay, well, and I know that you mentioned early on in your argument, something to the extent of, once we get to, is it privileged, is it not privileged, then we get to who reviewed it, who looked at it, how it was considered. That's July's agenda, actually, from what I understand. So I just want to get through June so that we can get to July, quite frankly.
And I think at some point I'm probably making a record. However, I think when the court rules, and I'm getting the sense perhaps the court may be ruling against me, but that's okay. I think the court has to issue an order that tells us what to do rather than, because we seem to have different opinions about that policy. So I think the court might have to put in its order, this is how it's going to roll, I think is what the court should do, not just
Grant the motion.
Correct.
Well, so I thought about that again. Why I was hopeful that once we actually had this detailed, lengthy policy or proposed protocol to look at, that there would have been an ability to have some thoughts on if the court determined that it would be appropriate for a filter team to be utilized, is the language that's in this policy something that the parties agree, or there should be an alternative? I can do that. I mean, I can clearly go through and indicate if there's any language in here that I feel should be different to comport with what I think the case law states, or in this situation, if you believe that there's something that you're not in agreement on in terms of how the terms of the proposed protocol read or would be executed,
May I suggest this, Your Honor?
I'm happy to weigh in on it.
It sounds like the court is going to allow the Attorney General to use the team. I don't want to say I'm prejudging the court, but I'm getting the sense I've appeared for you. Perhaps Mr. Kessel and I can propose an order to the court as we would in under a 7-day or something like that. And if there's any portion of the order that either one of us disagree with, we can file our objection. But that way we can write the order, and as I think the court encouraged us to do, without waiving my objection, it can be noted, and we can try and fashion the order. I try to make less work for the court, recognizing where I think the court's going.
I think it's still appropriate for me to make a decision on the motion in general.
Right.
I reviewed the proposed policy, and to the extent that any of the language included in the proposed policy or protocol, I should call it, is confusing, or there's some disagreement on how it would actually be implemented. I didn't really have an opportunity to weigh in on it. It appeared that the parties were taking very opposing viewpoints, that the people believed that the filter team is an appropriate way to address the issue of potentially privileged materials that were seized pursuant to the search warrant. And the defense was taking the position that under no circumstances was this something that the court could approve. So I didn't get into the details of the proposed protocol. I think in terms of issuing an opinion on whether or not a protocol can be established to address the potentially privileged material, I'm in a position to rule on that today. I guess what you're asking is if I'm telling you that this is a protocol that the court is going to require to address the potentially privileged material, do you want an opportunity to weigh in on what that should say? I'm not sure what you're asking.
I guess, Your Honor, what I'm hearing is that the court is not going to order the relief I request is in that the documents come to the court and the court exercise its authority to determine whether they're privileged or not. In that case, what I'm hearing Mr. Kessel say to the court is that I get the results of the searches by this vendor first before the privilege team or team gets to look at anything. And I get to make the, or Ms. Peterson gets to make the determination as to what we believe is privileged or not. That's what I'm hearing Mr. Kessel say, and that's, I guess, where I'm trying to find out what happens next.
Okay. Is that what you said, Mr. Kessel?
And Judge, what I'll say is part of the policy is also that there will be timelines that will be agreed upon. So for example, if Mr. Gleason, we've got the potentially privileged documents, right? And then, okay, we have X number of days to go over these documents. And there is, in the policy, it says, it's agreed upon that you can do X number of pages like per hour, right? Because what we don't want is a practice where, okay, well, we have this review team, but it's going to take a year for everybody to go over everything, because that's not practical and that's not in the interest of justice and all that good stuff. So what we have are timelines that are set in the policy where we say, okay, this amount of work is going to be done at this point. So, the process keeps moving. So if that kind of answers the question. But yeah, Judge, yeah, Judge, I think that's the people's position. I don't know if I'm really in a position to negotiate a department policy as far as particular issues that Mr. Gleason may have. I think ultimately the question is, does this court believe that this policy adequately protects the defendant's rights? And if it does, then, we ask the court would adopt it.
I guess I'm struggling with your interpretation as well, Mr. Gleason, only because it appears as though what is being requested would, I'm not sure, it sort of negates the whole point of having the filter team. My understanding of the way that this proposed protocol would work, both sides, meaning Mr. Kessel, Mr. Gleason, his client, the other attorneys that are working with Ms. Peterson, they have an opportunity with some sort of time limit, because I'm going to go out right now and tell you, this is something that I should have seen in March, quite frankly. And I'm a little bit frustrated about that, but I'm happy we're having an opportunity to fully explore this issue so that I can make a decision and nobody comes back at a later date and said that there's now a fatal flaw to the case because we didn't go over it. But that being said, my understanding of the proposed protocol is the two sides together are going to work to develop a comprehensive list of search terms that they believe, if utilized, will have the potential of catching any potentially privileged communication that your client had with attorneys leading up to the seizure of these devices.
Right.
And both sides get to weigh in, and I don't care how many search terms are on there, quite frankly, as long as both sides have an equal opportunity to weigh in and provide what they believe would be appropriate. If the two of you can't agree, or the two sides cannot agree on whether or not a particular search term should be included, you come back to me. I have the responsibility of making a decision, which I think is a responsibility that I will maintain on this issue until the case is over here, quite frankly. So I don't see any part of this as a decision that I would make today that would relinquish my duties to somebody else. So come back. We will argue about the search terms. I'll make a final decision. Once we are confident that we have a complete list of search terms that will identify any potentially privileged communication that may have taken place between your client and her attorneys leading up to the seizure of the devices, it goes off to a third-party vendor. Clearly not somebody that's involved in either person's office in any way, shape, or form. I'm assuming the work that they do will be somewhat monotonous. It's going to be data, it's pulling data based on these search terms, not even something that you're going to have a number of individuals like laboring over to determine. Once that information is produced, however, my understanding of the protocol is that it goes to the filter team, not to the defendant, because if it went to the defendant to identify what's potentially privileged or to put it in all these categories, then I'm not really sure what the point of the filter team would be. And I'm still planning on issuing my actual opinion on that, but it goes to the filter team. And then the filter team has to work through each of the categories to make a determination. But at each point in the proposed protocol, whatever category it is identifying a potential document to fall within, there is a process that once the review team or the filter team or the taint team makes the determination, it goes over to you to look at it, review it, say, yes, this falls in this category. No, this doesn't fall in this category. We don't agree with you. We're going to take this one to the judge, and the judge is going to review it and make the final decision. So that's my understanding of how everyone would be involved in this process. I understand that the preference, of course, would be for Ms. Peterson, that once the third-party vendor gets all of these documents, gathers them pursuant to the search terms that you've put together, everything just goes over to Ms. Peterson for review. But I don't think that's what the review team or the taint team is put in place for. So I didn't expect that that would be the outcome. And I don't think Mr. Kessel is saying that's what the policy would require, but I still find the safeguards that are necessary throughout the policy in that both parties are coming up with the search terms, and there's no limit to what you can put in there, quite frankly. And if you don't agree, I'll make a decision. A third-party vendor then identifies anything that could fall within that potentially privileged category, any of these categories. And once that information is provided to the separate and distinct filter team that is separate from the Attorney General's office, that is actually any attorneys that are working on this case, and they determine what category it falls within, at that point, Ms. Peterson has the ability to review, object, come to court. So I think that's what the case law is indicating, is the understanding of the filter team. I'm not sure, but
I think the court in denying my motion just now, I think has identified what the process is that the court intends us to do, and I understand that. So,
and I think it is supported. I'll just, and if you want to go back and sit by your client, you can. But I think it is supported by the case law, quite frankly. I think, especially as it relates to the in-ray search, sealed search warrant case from 2021, which I think is the most recent case out of all the ones that were cited here. It's very difficult for the court to find that this case doesn't apply here. Of course, factually, there are some differences, but as we indicated, I think we all agreed on, like in that case, in this case, the government is already in possession of the documents that they were seized pursuant to a search warrant. I didn't get any indication, anything that's been filed at the court thus far, that there's an issue with the search warrant per se. So nobody's asking me to invalidate the search warrant. This definitely wouldn't be the appropriate way to do that through this motion. It appears that both sides are truly concerned about Ms. Peterson's privacy right and her right to maintain certain types of communication with her attorney as privileged. It seems as though the attorneys are before the court because they are genuinely wanting the correct outcome for a procedure here that will protect her rights. I also, of course, took a look at the fact that this is in the process of a criminal investigation. Charges have been filed. That's actually something that has to be considered and is a little bit different, but nonetheless, I think it meets the standard that's outlined in that case for the court to consider the issue. I will note that in this particular set of circumstances, which I found to be different than the other cases, it's not the defense raising the issue, it's the people. So I know that this is an issue that has been negotiated, and it appears that the parties were trying to resolve this without the court. But in most of the case law, it's the defense, the defendant, the intervener that's raising the issue to ensure that their privacy rights are protected. Here, we had the state file the motion, making sure that before anything occurred in this case, that the court had an opportunity to weigh in and make a determination about the appropriate protocol to follow here. So that was a little bit different as well. But nonetheless, I really do think that this case is one that the court cannot ignore. I've taken into consideration the defense position that generally they're objecting to the use of the filter team, that they believe that it would be more appropriate for the defense to review the communication and make initial determinations about privileged materials, and then give the state an opportunity to review, and they can determine where to go from there. I also took into consideration the fact that the defense was offering in the alternative that the court consider the appointment of a special master. Of course, I'm familiar with the term. I'm familiar with the federal law that actually outlines the circumstances in which that person would be utilized. There was no case law that was provided to the court that would support the court's decision to appoint a special master over what the people are seeking as the implementation of this filter team through the protocol they've submitted. Most of the cases where I could find that the special master was appointed, very different than this criminal case, quite frankly. And I didn't really find anything that would require the court to consider that. And there was little detail that was provided beyond just asking the court to appoint a special master to address this particular issue that's before the court. There really was overall a blanket assertion that no person that has any relationship to the Attorney General's office should be able to serve on a filter team. And the court finds that this assertion in and of itself really flies in the face of the court's opinion in the in-ray sealed search warrant case from 2021. I think, let's see here. Despite the generalized position that the defense is taking that the filter team protocols that have been reviewed unfavorably by previous Court of Appeals decisions, when you take a very in-depth look at those decisions, it seemed clear to this court that while there is case law that criticizes filter team protocols, in those opinions, I think the courts did an excellent job of really defining what specifically they were taking issue with in those situations where the protocols were utilized. And in doing so, there is, I guess, a body of case law that's been developed that helps this court make a determination of what is appropriate, what isn't appropriate, and why that would be the case. So I think taking a look at the three cases that have been cited by the parties here, we have the 2006 case, which I know is referenced in oral argument as well in Ray grand jury subpoenas. There's some factual differences here, but of course, in this case, it was the government that argued they should be able to send a team in to review all of the documents. They did indicate that those would be government attorneys that were not involved in the case. However, the fatal flaw in that case to the government's proposed protocol was language that directed the team to immediately turn over information that they had determined was not privileged over, and it would go directly to the investigative team. The court really took issue with the privilege holder not having the right to object. And that there was, let's see here, not a clear opportunity, for the court to be involved in any final decisions on the issue where the parties did not agree. A clear addition to the language that allowed for this was sufficient to address the court's concerns in that case. The team procedure, however, even back in 2006, was otherwise supported throughout the opinion. Also citing the in-ray search warrant issued June 13th of 2019, a U.S. Court of Appeals decision out of the Fourth Circuit, which has come up a couple of times this morning. Again, while taking a negative view of the filter team protocol that was at issue in that case, the facts are clearly distinguishable from the case at hand. In that case, the protocol was actually established by a magistrate judge at the time the search warrant was issued. The timing was deemed flawed by the court, as the ex parte manner in which the protocol was established did not allow the privilege holder to raise issues as they should have or would have if it had come before the judge in adversarial proceedings. The case that the court really is focused on in supporting the decision that it's making today is the 2021 opinion in-ray sealed search warrant that the U.S. Supreme Court determined that the filter team protocol that was at issue in that case did not suffer from any of the same fatal flaws that had been identified in the previous cases. In this case, the protocol was developed during the course of adversarial proceedings, as it is now. Both parties were given an opportunity to weigh in. In this case specifically, we've heard that a third-party vendor, which was named and identified today, would be responsible for gathering potentially privileged documents based on input from both parties to develop a complete set of search terms. In the 2021 case, the court maintained its judicial function in making final determinations on privilege. The protocol also appropriately created a system of checks and balances so that nothing would be sent to the investigative team before approved by the defendant or the court. As I've reviewed the proposed protocol in this case, which is listed under Exhibit A, it appeared that the Attorney General's office has taken notice of the decisions of the U.S. Court of Appeals in determining what the protocol should be. Each step in the process provides adequate safeguards to protect Ms. Peterson's privacy rights. Furthermore, it makes very clear that the court would be the final arbiter and maintain its judicial functions on any and all issues that cannot be resolved by the parties, which would immediately be brought to the court to make a decision based on the law. So for all of these reasons, I think that the people's motion should be granted. To the extent that you want to provide a written order, you can do that if that's the preference. I think other than that, you would get an order indicating that I've made my decision for the reasons stated on the record, so we could get it quickly. But I'm happy to entertain an opportunity for you to submit something under the 7-day rule if you'd like to craft language that you think may better guide you through the process. Oh, and to the extent I might have just said a Supreme Court case, it was the U.S. Court of Appeals decision 2021. All of them were. And I hope I identified the appropriate district, but I'm going to make sure that the record's clear.
Judge, I guess I don't think we need to submit any additional orders if the court is saying that the policy can be adopted. I think we're okay. What I will indicate is, even though the court hadn't ruled yet, and I have spoken with Mr. Gleason about this, in E sub 3, there's a requirement that anybody who discovered, and that's on page 3, Judge, the individual or team that discovered the potentially privileged material must create a detailed record documenting how or where it was found and any actions taken thereafter. I have been in touch with Detective Trigger. I do have a list of Troy PD who came into contact with any potentially privileged information. I'm going to get that list of people. I can get it to Mr. Gleason probably before we leave the building. Those reports are being created, so those will be got to him as well, because I know that's going to be part of the motion that we're going to be hearing in July. So just to let the court know that's going on as well.
Okay.
And I won't belabor it. With respect to the court's first question, when I stopped talking, I think the court very clearly laid out what it expects. So I don't think we need an order. I think that's a testament to your abilities as a judge. In response to Mr. Kessel, I've previously off the record indicated that, and this morning, that the Troy Police Department looked at these devices electronically without a taint team. It's my understanding, and I can be corrected, that when they were looked at, no reports were prepared, which I find unusual. And those reports are now being prepared at the direction of the Attorney General.
Okay, so that's information that you just would like to make part of the record.
Yes, Your Honor. Thank you.
Okay. I will still generate a written order just indicating that the motion was granted for the reasons stated on the record. But can we just touch base about our next plan to get together, which is in July? We did pick a tentative motion date, but obviously the actual written motion has not been filed.
The court has informally, through Ms. Eversole's direction of the process, that I'm to file the motion no later than June 20th.
Yes.
And that will be timely filed by the 20th.
Okay. And then once I receive it, I don't know if we had given you a response time. Clearly, I'm just trying to get it close enough to the date that we are expected to have a motion evidentiary hearing. But I would like time to review it myself. So once we receive that, we'll give you an actual deadline, Mr. Kessel. And then we're still good potentially to be proceeding with that date that we've selected, which was Monday.
July 13th.
14th.
14th, sorry.
The 14th?
Yes, Your Honor.
Okay. I think that's it for today. Ms. Peterson, my recent information from pretrial services tells me that you're fully compliant with all bond conditions. So my intention was to continue the bond at this time. Is there anything else we need to address?
Not today, Your Honor. No.
Thank you, Judge.
All right. Thank you.
Thank you.
May we approach Your Honor briefly?
Of course you can. Just let me go off the record.
Thank you.
Okay. Would you rather just have a conversation in chambers so they can pack up?
That would be great.
All right. Thank you. Make sure they
All rise. Court is now in recess.
All right. This is 251620, the People versus Justin Minter.
Good morning, Your Honor. James Gazicki on behalf of Mr. Minter. We're unable to resolve this case. Request a jury trial.
Okay. So we'll set this for a jury trial. And Mr. Gazicki, I'm looking at dates. I have you here. 3 city and state cases this date. September 5th of 25. I have you here on 2 other potential jury trials.
That's good, Your Honor. That's good.
All right, so the jury trial on this case, Mr. Minter and Ms. Lewis, will be the earliest date I have right now is September 5th of 2025.
Okay, I mean, him not taking it is just going to make him miss out on the birth of his daughter, but that's...
All right, well, ma'am, Ms. Lewis, I'm notifying you of a court date. Under Michigan law or the Constitution, everyone has a constitutional right to a jury trial if they're so inclined, and I'm not going to impede on that right. And Mr. Minter's made a choice, and we'll all respect that choice. We'll have a jury trial. Miss Louie's not in here. I guess we'll notify her of that date since she's the prosecutor on that. We'll see everyone back on that date, and bond will continue. That means all of my bond conditions continue until that date. No contact with complaining witness or her address. She can't go to where she lives, works, goes to school. No contact through any means. You understand that, sir?
Yes, Your Honor. And I have a quick question.
Okay.
So I'm not supposed to have contact with her, right? She shouldn't be having contact with me though, right?
Neither of you should be communicating with each other. You are charged with the crime, sir. So you have a bond condition that you can have no contact.
And that's what I'm trying to say. I have not had contact with her, and she has been contacting me.
All right, ma'am. Ms. Lewis, there's no
There's
contact.
no. I don't have his number is blocked. There's no.
Okay, good. Listen, Mr. Minter, I'm not here. This is not Judge Judy. Listen to me. The person named as a victim in this case cannot change, alter, or amend this order in any way. She can't change it, only I can. If she's to invite you over, ask to meet you somewhere, or contact you for any reason, you cannot violate this court's no contact order. And if you do, you'll go to jail. And if you have that issue arising, Mr. Minter, I encourage you to contact your attorney, okay?
Okay.
All right, we're all set. Everyone have a good day.
Your Honor, can I speak to Miss Lewis in the breakout room?
Yeah, we'll put Miss Lewis back in a breakout room for you.
Thank you, Your Honor.
All right, can I get that file, Mr.? Who has the file on the Buford? Is it back in my chambers? Oh, it's right here, sorry. Oh, our small one has it. All right. All right. Come on up. And Miss Lewis, you'll see something asking you to join a breakout room. Mr. Minter, you're all set for the day. Mr. Kinney, I need just 1 second. I don't know if Mr. Calderon is still here. Talk to him. Have you talked to Mr. Calderon?
No, I haven't, Your Honor.
All right, we'll put you in with him. Have you reviewed the PSI?
I don't have a copy, Judge.
Can you send me a text? Can you put in the chat your email and we'll get it to you?
Yes, Your Honor.
Okay. All right, so put it in the text. We'll get it to you. We'll put you in a room with Mr. Calderon. Miss Lewis, join the breakout room to see Miss Dennis.
I don't see anything yet.
Give me 1 second. I'm trying. Give me 1 second. All right, I'm putting her back in prosecutor 0. So Miss Dennis, she'll be in there for you. And Miss Lewis, just join that breakout room. All right, we're on record again. This is 243391OM.
Co-defendant on behalf of probation.
Morning, Your Honor. Jeffrey Fanto on behalf of Ms. Buford. Wait formal reading, request all warrants be recalled.
All right, the warrants will be recalled.
Judge, we would ask that this matter be treated as a violation hearing date. We've had discussions with my client, had discussions with the court. And I had discussions with Mr. Zick this morning as well. Ms. Buford understands she has a right to have a hearing in this matter. And she understands the allegations that she missed her show cause, missed her orders appointment. She's prepared to enter a plea of guilty to that. It's my understanding, based upon conversation with Mr. Zick, that her 771 would be amended to a 3-month period, which is now passed. That would be closed successfully. The balance of the fines and costs on that would be waived. And she has a payment plan continuing. The bond, or her May payment, which was intended for the payment plan, which ended up being treated as a bond payment on the OM file. We'd ask that payment be shifted and treated as a payment against her payment plan for her May payment. She obviously has a June payment coming up. And the traffic file is really strictly a collection file at this point. It shouldn't be tied to the dangerous weapon file at all.
Ma'am, do you understand all that?
Yes.
All right, Ms. Buford, don't come up here with the attitude. Just shrug it off. Listen, ma'am, you understand you're here today for a violation of your probation?
Yes.
Is that a yes?
Yes, ma'am.
All right, you understand there's an allegation that you failed to appear for your orders on your probation.
Yeah, yes. Ma'am.
I'm trying to find the actual. I have the recommendation. I'm looking for the actual violation. There's an amended allegation that you failed to appear for your orders appointments on 4/4/25 and 4/14/25. Do you understand those allegations?
Yes.
Okay. And did you go over your rights with your attorney?
Yes.
Did you understand your rights?
Yes.
And did you sign and date that form?
Yes.
Ma'am, you understand you have a right to a hearing on this allegation.
Yes.
Okay. And if you enter a plea of guilty, you'll be waiving those hearing rights.
Yes.
Okay. And you understand that this is a well, it's first technical?
No, Judge, because it's a delayed version.
Okay. You could get the maximum possible jail time on this.
Yes.
You understand that? Okay. For that. All right. So knowing all of that, ma'am, how do you plead to the allegation you failed to appear for your orders appointment on 4/4/25 and 4/14/25? Has anyone forced you to get you to plea?
No.
Has anyone promised you anything to get you to plea?
No.
Are you pleading guilty of your own free will?
Yes.
All right. So on the case ending in 243391, the one we just took a plea on, to the probation violation, she posted a payment and it should have been applied to the other case, and it was applied as a cash bond on this case.
It should have been applied to her.
Yeah, it should have been applied
Payment
on
plan may
two.
incorporate another file, I'm not sure, but it just should have been applied to her payment plan.
Yeah, to 2662, applied line to, I'm gonna say 232662. So you'll get credit for that payment, okay? And then the prosecutors agreed to amend this to 771.1 to a 3-month term of probation. So I am going to grant that. I don't see that she's picked up any other cases or anything.
No.
So you're keeping that status. I'm closing the probation. I'm allowing you to keep that status. But the way you've behaved in this court is so egregious. Do you know, like, you're grown. How old are you?
22.
You're 22 years old. You cannot come into places, a court, the one place in the world I could put you in jail. The one place you can't come into screaming, yelling, screaming the F word at people is here. You can't do that. Are you confused by that?
I am a little confused by it because I was with my mother and I don't cuss in front of my mother. So I didn't scream any F words or I didn't say any F bombs or disrespect anybody because she was standing right next to me.
You weren't disrespecting anyone down there.
No.
So then why do my court officers have to come out? And why do all the notes in the file on January 3rd, you called up to the court. This is another staff member. This is just another random staff member in the building writing a note. very, very rude to all staff, screaming in my ear about her ticket, wants to know why she has a felony. She would not let me talk. These are the ROA notes. Then you cancel your appointment twice. My probation department's advised me that, you know, you and Kelsey, you had worked with Ms. Havner. She had to hang up the phone because of your behavior. And then after that, you called back again and you spoke to a clerk in the probation department who doesn't know anything about your case. And you were screaming at her too. I've got notes from so many different clerks in this file. Asked what I can help her with, and she began screaming at me. She wanted to talk to a supervisor. I tried to transfer, but she refused to talk to her. I had to terminate the call because she continued screaming and using profanities and would not let me speak. I mean, it's like there are note after note after note. I know that they had to call the court officers to the probation department because of your behavior in probation yesterday and demanding that I see you forthwith. I have dockets and you were on it at 1 and then you chose not to come back at 1. And it's like, this was a minor, you know, overall offense. I mean, I know that because I sentenced you immediately from the bench and just gave you non-reporting probation. All you had to do was come in and do your orders with Ms. Havner, not pick up any new cases. And you can't do it. You missed that appointment 2 times. It's like a lack of self-control. Everyone here is the bad guy. So your payment plan continues on the driving while license suspended and the civil infraction for expired plate that you have. On this case, I'm closing the file. You will keep your diversionary status. You've got no prior criminal history. You're young. I don't want to make you a criminal, even though it seems like you want that on your record. I'll waive the balance because you're doing 5 days jail forthwith.
But she report on Friday.
No. Ma'am, an appeal to circuit court may be taken within 21 days of the date of sentence or is permitted pursuant to MCR 6.625 parent B. If the sentence includes incarceration and you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint the lawyer to represent you on the appeal. If the request for the lawyer is made within 14 days of date of sentence.
Thank you.
You taking her to jail today?
She's going right now.
Can I at least get a hug or something?
No, but if she has anything she needs to give you, she can hand it to the court officer. Ma'am, I see where she learned it.
No, she didn't learn it from me.
Hey, Mom, go! Mom, go! Go! Mr. Wallach, have you had any contact with Mr. Massa?
Not since the last court date, Judge, when he was incarcerated.
So the jail has been here since like 9 o'clock. And
All
then
right.
I got Mr. Kenny on. So he's talking to him and I'm hoping after that I'll produce some because they only have 1 jail book.
All right, so he's in county. We have him meeting right now with, someone's meeting right now with their client. And so I'm guessing as soon as they're done, they'll put Mr. Mass on screen for you. Okay, Mr. Wallach?
Thank you, Judge. And if I could get a breakout room with him, I would appreciate it.
Yep, as soon as we get the jail back, as soon as Mr. Kinney is done at the jail, I'll call his client's case. That's a very brief hearing. It's a sentencing, and then I'll get him the jail in a room for you.
Very good. Thank you, Judge.
All right, thank you. And And Mr. Bartlett, did you already meet with the prosecutor and your client?
I did. And I don't know if you want me to elaborate, but I have.
Well, let me see, let me just ask this question. Is your client here?
He was in custody with MDOC. My understanding from his daughter, who I believe was observing, noted that he was present, but I do not see him in the gallery at the moment. I can tell you the prosecutor was asking for a 1-week continuance.
We got it. One sec,
Okay.
Don't tell me all that. Let me get him in. We found him.
Okay.
Sir, can you tell me your first and last name?
Todd Poupard, P-O-U-P-A.
Can I get that file, officer? All right. Okay, Ms. Maudlin, this is 240136FY, the People versus Toddy Poupard Council.
James Bartlett, P57249.
Mr. Poupard, one more time, can you tell me your first and last name?
Todd Poupard.
All right, and I have a note in the file, counsel, and I don't know if you had a chance to look at this, that it says, I wrote this last time we were here on 5/19, and he was not brought over. Defendant in prison, we need to writ him for arraignment. There may have been an offer that dismissed this case. And did you have a chance to speak to the prosecutor about that?
I did. So the prosecutor is requesting a 1-week continuance. My understanding is she's awaiting input from the circuit court prosecutor who had written up the settlement offer notice of acceptance plea agreement back in March of 2022 for dismissal of this case.
All right, so she just needs a chance to talk to her people up at circuit to make sure.
Yeah, that's what she advised me.
All right, well, I don't mind a 1-week adjournment, but I don't know if we can get the writ paperwork over to get him on screen in a week. And I presume Mr. Poupard's in on something else. So I'm gonna have to set it out for 2 weeks so that we can get the writ done.
And if I may, he's not there for anything. He's not there for anything else. This is holding him up. He's eligible for parole, but they need him to straighten this up. Assuming that dismissal comes through, if that provides the court with more info.
All right, well, in that case, if he's only in on this, then we'll set it for next week. Next week is a rough week. We'll do it at 8:30 a.m.
8:30, got it.
And then hopefully the prosecutor will have an answer by that date. Because I certainly don't want to hold someone up in custody if they're being held on a case that should have been dismissed.
Agreed.
So, and can I just ask Mr. Poupard or Mr. Bartlett, if you learn that's the case before the week is up and you have communications with the prosecutor, would you waive your client's presence for me to just put the dismissal on?
Absolutely.
Yes, Your Honor.
Okay, and that way we don't have to worry about the writ holding you up to try and get you on screen to tell you your case is dismissed. I'm sure you'd rather us just send that paperwork over.
Yes, Your Honor.
All right. So will you just let us know if you have conversations with her beforehand? Will you let my criminal clerk know, counsel?
Cross my heart and hope to die.
All right, we're all set then. We'll see everyone back next week at 8:30.
All right, thank you.
Thank you, Your Honor.
All right, have a good day.
Thank you.
All right, Mr. Calderon, this is 251163, the People versus Pablo Calderon.
Yes, ma'am. Good morning, Judge Robert Kinney, appearing on behalf of Mr. Calderon.
All right, so this is the time and date set for sentencing. Mr. Kinney, have you had an opportunity to go over the pre-sentence report with your client?
Yes, I have, yeah.
All right, is it accurate and complete?
No, that situation about him punching his mother, he says that's not.
The drugs being what? I'm sorry.
No, him punching his mother, he never punched his mother. He says that's not about hitting his mother.
Judge, if I may.
Please.
Matt Keys on behalf of probation. I believe the information that he is talking about is in the second.
It is, and it's
paragraph
something
in the
he said to
summary.
you during the assessment?
That was a direct quote from him while we were discussing his family and support.
All right, I'm just gonna make a note. My probation officer says this is a direct quote during the PSI, but I'm just writing defendant denies saying this, okay?
Thank you, Judge.
Otherwise,
It's correct.
all right, Mr. Calderon has a criminal history dating back 13 years, multiple, he's got assaultive cases, he's got, unlawful driving away, a few involving drugs and alcohol. This was reduced down from a felony, correct, to a misdemeanor?
Yes.
Anything in terms of the sentence recommendation?
Well, I see the recommendation, but we have an agreement to probation.
I'm sorry,
Under the plea, we have an agreement to probation. It's obvious that he needs some treatment. But I'm asking that you follow the agreement and give him all the treatment he can get.
is he currently on felony probation?
Yes,
What's he in custody for? Just this?
yes.
From my understanding, he is in custody on this.
All right, but he's got a parole officer and he's being monitored at felony court for,
He has an MDOC agent that he's working with.
He also has about 5 warrants. He has
I'm sorry, Mr. Kinney, you broke up so bad.
He also has about 5 warrants got to take care of before he can get out.
I need to take care of this one first.
I mean, my probation department, based on his behavior during the meeting, does not believe he's an appropriate candidate for probation. He denies doing anything wrong, placed the blame on someone else, has no remorse for his actions, no desire to change. I mean, Mr. Kenny had a felony reduced to a misdemeanor. I mean, that's a sentencing agreement, but I'm inclined to just give him jail time. If he can't sit through a PSI and take any responsibility for something he pled guilty to, a felony reduction, I'm not inclined to just go have him have my probation officers chase him around for a year.
Oh, man.
Okay, well, Judge.
You said me?
He suffers from bipolar disorder, schizophrenia, and depression. I always ask my client not to make any statement with regard to the facts of the case, probation, just because.
I mean, there was a sentencing agreement on this case. I don't have to follow it.
I agree.
Listen, I mean, my inclination is not give him a year in jail. But I think he needs 90 days. I mean, I don't know that I want my probation department to chase him around for the next 12 months. And I understand he has other issues, but that would be my inclination, Mr. Kinney. And to just close him out.
Mr. Calderon.
Yes, sir.
90
days. I thought I can't get probation. I'm taking classes right now. I got an appointment to go on the 19th to go to rehab for mental. It's on Woodward and well, let me find it. It's on It's on Wayne State University, Tallinn Park, 3901 Chrysler Drive. I got it right here. It's my appointment, so I could go in already. I'm taking Suboxone right now for what I dropped dirty for, and they're putting me in the class right now. So as soon as I get out and I take care of these worms, I'm gonna go straight to rehab from here.
Mr. Keys, there's a sentencing agreement. It sounds like he's got 2 other probation cases. He's got a history of
Drug.
mental health issues that may have made him behave this way. I'm gonna give him a chance.
Okay.
But you're doing 12 months probation, random drug and alcohol testing. Comply with felony probation. You're gonna have to test, sir.
Yes, ma'am.
No drugs or alcohol. You can't surround yourself with people who do drugs or alcohol.
Yes, Your Honor.
You can't go into places that the primary purpose of the business is drugs or alcohol.
Yeah, I understand, Your Honor.
Judge, for the record, if he's already testing through his felony probation, do you want him to just test there, or would you like to test?
I guess the question as it goes to testing is, are they testing him is he going in once a month and testing, or are they testing him somewhat consistently?
Right, okay.
I'm going in twice
Mr.
a
Kinney, yeah, Mr. Kinney,
Yes.
we will coordinate, my probation officer will coordinate with his felony probation officer. And if he's testing randomly, we'll allow those tests to count as our tests. If he's not testing randomly and he's going in once a month and testing then, I mean, he kind of sees that coming, and I'm not gonna count that test, but you can't break any new laws. You can't leave the state without permission of the court.
Your Honor, can you let Mr. Calderon know what could happen if he violates any of this?
If he violates this, I mean, I think we're going, this is an exercise in frustration, but felonies court has determined he's eligible for probation there, so I'm going to follow the sentencing agreement. But Mr. Calderon, if you don't do these things or you abscond from treatment, I'm just going to give you the year in jail.
I understand, ma'am, and I'm not. That's why I'm already been going through this. I already made appointments before I even get out, so I won't relapse or nothing like that already.
He's to attend mental health and substance use treatment.
I got that going on already in Team Wellness.
She telling you what you got to do now, Mr.
To report, sir, Mr. Calderon, if you're already doing these things, you're just going to do the things you're already doing, right? Our probation department will coordinate, but these are the things I'm ordering you to do. So if they're not, you're doing them.
Yes, ma'am.
Continue on, what are you taking, Suboxone?
Yes, ma'am.
Continue taking Suboxone as directed. What am I missing? You have a fine of 200, court costs of 200, probation oversight fee of $450. You have a crime victims' rights fee of 75. You have a state assessment of 50. You're to pay that over the course of your probation. Your total's $975 you have due in the court over the course of your probation. And one of your terms, sir, is Mr. Keys will get an order from your felony probation, just in case I'm missing anything since I'm sentencing from the bench.
There is, if you don't. I wouldn't mind seeing either GED or high school seeking employment or obtaining employment, I should say.
You're going to obtain your GED or diploma or work towards it. You're going to work towards employment, finding a job. You're going to clear outstanding warrants. And once we get that, you're to comply with felony probation. So whatever additional terms they have, you're going to follow them as well.
Yes, Your Honor.
All right, we're all set. Thank you, Mr. Kenny.
Thank you.
Do I have everyone in on 251659 FY, the People versus Nathan Kirkwood, and 251660 FY, the People versus Gavin Dale or Gavin Bruce? Yes. Can I get your appearance, Mr. Dox? All right, everyone, we'll try and get Mr. Dox on. He's in the courtroom, but I can't. I've got lots of cases here, so I just have to keep moving while we're waiting for him to log on or get audio. All right, this is 250229, the People versus Cherie Lee. Hi, Miss Lee. Come on up. All right. So I need a second on Miss Lee's file. Miss Lee, we're trying to get all the people we need in the courtroom on any case, and I can't seem to accomplish that. So just have a seat. I'm sorry. As soon as I get the probation department up here, we'll call that. This.
There's a situation with that. It's the attorney here.
All right, that's fine. That's perfect on him. If that, I mean, that would be what he needs anyway. So, Mr. Dox. Oh, no. All right, on Massa, are we ready on Massa?
We are ready, Your Honor.
I'm ready, Matt.
All right, this is 251565 FY, the People versus Jason Massa.
Good morning, Your Honor.
Good morning.
Number 55741, appearing on behalf of Jason Massa.
Mr. Massa, can you tell me your first and last name, please?
Jason Massa.
Okay, so we're here today for the probable cause conference. What is the status of discovery?
Your Honor, we have all the discovery. We're asking to keep the preliminary exam date of June 3rd. I would just ask you do it at 11 o'clock.
Okay, well, let me tell you what I've got going on June 23rd. I have an 11, I can't do that. I have an evidentiary hearing with witnesses coming in at 11.
Okay.
I have at 10:45, we can try and squeeze them in. But so you know, I have 1, 2, 3, 4 exams in between 10 and 11.
Okay, that's fine, Judge, unless you prefer to move it to the 30th.
Well, he's in custody, so I don't.
Okay. 10:45.
I have it at 10. Mr. Wallach, I'm just keeping it at 10 and I'm making a note that says attorney may be late.
Very good, Your Honor. Thank you. And we would like to address the bond.
Okay, go ahead.
His bond is $25,000, 10%. He's a lifetime resident of Wayne County, with the exception of the last 6 months where he has resided in Monroe County with his sister. No felony. His last misdemeanor was 2016 for a DUI. There are no mental health issues. He is employed as a roofer. His mother passed away Thursday. He would like to be with his family. We're asking you for a personal bond with tether or a reduction to $10,000, 10% with the tether.
All right, Mr. Wallach, my one concern about this is that the allegation in this case is that the victim was, I believe, his brother.
Yep, that's correct, John.
So, I mean, in terms of, the problem is if I give him a bond for the funeral, and Mr. Mass, I'm very sorry about the loss of your mother, but he can't go to the funeral anyway because the complaining witness on the felony is going to be there.
He's not going to show. He's not going to be there, Your Honor.
Your Honor, I've spoken with the family. That complaining business, does not have contact with the family, and is really kind of off the grid. They don't see him.
Well, what do you do if you go to the funeral and he's there, Mr. Massa?
Then I would have to leave, obviously. I would leave the premises immediately with my sister and my father.
My phone just died, Your Honor, sorry.
One second. All right. I'll request a DSU report for next Monday. I mean, the allegation is it was a stabbing of a family member in the residence where all of these people were. I'm not inclined to, and I understand I'll do I mean, if you want to prepare an order that he can have some hours out to go to the funeral, but I just really think I'm creating a dangerous situation for everyone, including your client, by giving him permission to go to a funeral that the complainant could be at while this case is pending. I mean, and then we've got a bond violation, a situation at a funeral. It's just, so I'm going to request a DSU and I'm keeping the bond the same, but we'll address it next time. I'll ask for an urgent so we have it at exam next week.
That's fine, Judge. Thank you.
All right, we're all set. Thank you. All right, Mr. Docs, we've got everyone here on this now. One more time. This is 251-660-FY, the People versus Gap. Strike that. All right, this is 251-659 and 261689. Where are the two co-defendant cases? The People versus Gavin Bruce, and I should all, Mr. Bruce, could you turn your camera on? All right, so I have everybody here. Where did where'd Segura go? Can you see if we can grab her? We also have complainants present on this case. I should note for the record, Gallup, Jerry Gallup and Nathaniel Lambert are both present. Hold on, I need Mr. Mr. Docs, can I get your appearance?
Yes, good morning, Your Honor, and your staff. Attorney Quentin Docs, P number 79657, on behalf of my client, Mr. Kirkwood.
All right, give me 1 second so I can get Ms. Segura back in. And on your file, Mr. Docs, did you have a chance, or these dates that you and Ms. Segura, I see both of these, they're asking that I adjourn the PCC to next week because digital discovery was just sent. Is that correct?
That's correct, Your Honor.
So the exam on the 23rd was set for 10:30 a.m. And we'll just adjourn the PCC so that everyone has a chance to review discovery. We'll adjourn it to 6:30 at 10:30 a.m. And everyone can still appear at that date via Zoom. And then we'll have to do the exam on the 30th at 10:30. Can you do that date?
Not at 10:30, Your Honor. I have an exam in Judge Marlena Taylor at 36th District at that time. I could do it early afternoon, or I could do it the 30th, and my client could waive the 21-day rule. Oh, I'm sorry,
Well, it would be the 30th or July 7th.
Yeah, the 7th works better, Your Honor. That works better, and if we can do it before 10:30 or after 10:30, that's fine.
All right, well, if it's July 7th, we can pick the time. I don't have anything set on that date, but I need Ms. Segura because they're co-defendants and I don't want to set, she's coming, okay, because I don't want to set it on a date and then her come in and it not work. Ms. Segura, I know you've been waiting patiently. I need you the minute you leave. Yes. Can I get your appearance on Gavin Bruce?
Yes. Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Mr. Bruce.
All right, so on Mr. Bruce, we have both defendants out on bond. I have a request that discovery was just sent and we would adjourn the PCC to June 23rd. Is that correct?
That works for me, Judge.
And we're gonna adjourn the PCC to 6:23 at 10:30 a.m. Everyone can appear on Zoom. Discovery was just sent, so that's appropriate. And then we're looking at days for the exam, and the days are the 30th, but Mr. Dox is jammed on that date. The other date would be July 7th. Can you do July 7th?
July 7th works, Judge.
All right, Mr. Dox, if we do it on July 7th, can you do it first thing in the morning?
Yes, Your Honor. I could do it first thing in the morning.
Mr. Dox, I will tell you this. I take the bench. I'm in the building every single Monday at 8:30, and I sit here until 9:30 or 10, waiting to start calling cases. So if you're here at 8:30, we'll get you out the door well before 10 o'clock.
Roger that, Your Honor. I'll be there then, for sure.
All right, if everyone's here, we'll start right at 8:30, and you'll be the only thing I have to do because nobody else is ready. So bond will continue. I'll see everyone back July 23rd at 10:30 a.m. in person. And then to my the defendants and the complaining witnesses, you'll need to appear in person at the 23rd District Court, July 7th at 8:30 a.m. for the preliminary examination. Okay, and bond will continue until that time.
And Your Honor, can I have a breakout room with my client, please?
Yeah, we'll put you in with your client. So we'll put Mr. Kirkwood in with Mr. Dox. And then Mr. Bruce, your attorney will call you, okay?
Yeah, thank you. No problem.
So we have the dates, and then we have this other case that's alleged to have occurred on the same date. So that'll just, or 2 days later, he's got this other MDOB above 20. I'm gonna just have the same dates. Okay, so we'll do this one at the same dates as the other ones, but they have a date, different incident date.
Okay, Your Honor, can I go in the breakout room with victim Nathan and victim Jerry?
Yes, ma'am, we'll get you right in.
Thank you.
And that other case you have, Mr. Bruce, for the MDOP, same date, 6:23 at 10:30 a.m. for your PCC. An exam is July 7th at 8:30 a.m. Okay?
Okay, thank you.
All right, we're all set. Thank you.
All right, you have a good one, Your Honor.
And we're waiving the 21 days. If we go over it, there's good cause. It's co-defendant's discovery was just received. This is Mr. Martin. All right, this is 251756, the People versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at 9074 Clippard in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned. Yeah, he's just. Oh, so you know the original charges against you. And part of those charges against you, let's see. You could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address at 9074 Clippard. And you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations, it looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, officers were dispatched to that location. And there are allegations that you entered the residence through the back door, and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
So I move to dismiss the charges because one, well, the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity defendant, which is not me, I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm gonna say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
So, okay, well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
So like I said, I moved to like I said, bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition violation is legit anyways. And there's no probable cause for this case. I shouldn't have been arrested illegally anyways because there is no evidence. My sister lied. Her allegations are a total lie.
All right, you have a right to remain silent. Anything you say orally or in writing can and will be used against you, sir. You understand what the allegation is? You were just arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr. Martin, this is, I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I don't have a choice. I have another house to go to for one. Besides violating my rights.
Well, now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
guess what?
jail.
You
We'll
guys
see you
are
at your next
violating
court date. All right, thank you, officer. We'll see you next time, Mr. Martin.
Goodbye, Mr. Martin. Okay, goodbye. Have a seat, Eric. All right, Mr. Reed. Mr. Martin, knock it off.
All right, this is 251757, the state of Michigan. This is Jacob Tyler Reese.
Good afternoon, Your Honor. Jeffrey Fanto on behalf of Mr. Reese. Waiting, make the stand.
All right, sir, did you go over your constitutional rights with your attorney?
Yes.
Did you and I'm gonna hold that up. These rights on this advice of rights form?
Yes, he did.
Did you understand your rights?
Yes, ma'am.
And did you give Mr. Fanto permission to sign your name on that form?
Yes, ma'am, I did.
All right, for purposes of arraignment, I've entered a not guilty plea. Okay, and I've also, Mr. Fanto, I'm sorry, did I get your appearance?
Yes. But just again, Jeffrey Fanto, White Formal Reading Staff.
Gotcha, okay, and then I've signed the request for a court-appointed attorney. We've entered a not guilty plea on your behalf.
Judge, the complaint warrant shows 7157. It should actually show 7167.
Yes, Your Honor.
All right, so I'll make a note.
Everything else seems to be right.
So that's been noted for the file. Not guilty plea's been entered. He is currently on,
He has a HIDA,
he's on HIDA probation.
but no convictions and otherwise, Judge, and he has no holds. He is employed.
Is this from, is he still on probation?
Yes, ma'am. From my father and I, we had a little fall through about 3 years ago, and I broke into his house and I got a home invasion charge. It's just between
Okay,
me and
I
my
don't,
father.
sir, I don't want all that. I just need to know if you're still on probation.
Yes,
Okay.
ma'am. On HIDA.
Yep.
He's got about 6 months, 7 months to go.
Was the person that case is about Jenna Brewer?
Ma'am?
Was that case about Jenna Brewer?
No, ma'am. Just as a whole separate thing, with what I have going on.
That's all I need to know.
Yes, ma'am.
I don't want you to tell me anything else, sir. You got a right to remain silent. Okay.
Yes, ma'am.
I have advised him of the court's policies regarding no contact, as well as the ability to get an officer assist. He would be able to provide an address within 24 hours, Judge.
All right. I mean, there's some concern I have that he's on HIDA probation. I understand that's what it is, but it's literally for a count, you know, involving domestic, and now here we are again.
I understand, Judge. I would also note that again, he said about 7 months left. It does not appear to be any history of violations or anything in that regard. I did advise him he needs to let his probation officer know about the charge.
All right. Well, sir,
Yes,
I'm giving you a $10,000, 10% bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Jenna Brewer. Do you understand me?
Yes, Your Honor. May I get a phone call for the bail, or at least any phone call period?
And is Donna's last name also?
Brewer, yes.
You're not to have any contact with Jenna Brewer or Donna Brewer. Do you understand me?
Yes, Your Honor.
Mr. Fanto explained to you what I mean by no contact.
Yes, Your Honor.
You can't call, you can't write, you can't. Listen, Mr. Reese, listen to me, because if not, you're not gonna remember what I told you, or you're gonna say, oh, you didn't say that last time I was there, and I wanna make sure you hear this, because it's the most important thing I'm gonna say to you.
Yes, Your Honor.
You're not allowed to have any contact of any kind. You can't call, you can't write or email, you can't send them anything. You can't go to where they live, work, go to school. You cannot return to 7167 Campbell. Are all of his belongings there?
Yes, Your Honor.
You can have one-time visit to obtain your belongings with a police officer. So you have to talk to the police before you leave to set that up. Don't just go to the house and think they'll be there. You have to talk to the police and set up a visit so you can get your personal belongings. You cannot possess or have access to firearms. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. Sir, you need to delete them from your phone. You need to block them from their phone.
Your Honor, my phone is broken because she broke my phone.
Okay, if you see them in
I don't know if I can make a phone
public,
call after I get out of here.
You can ask to make a call at the jail.
Okay,
Okay, but listen. You can't call them, write them, email, don't communicate with them at all, don't have anyone else do it. The only one that can contact them on your behalf is your attorney.
yes,
You
Your
can't
Honor.
send them empty messages. If you see them in public, in a store, restaurant, a park, you're to turn around and leave immediately. If
Yes,
they
Your Honor.
contact you, do not reply. Okay? If they invite you over or ask to meet you somewhere or contact you for any reason, you cannot violate this court's no contact order. And if you do, sir, I will revoke your bond and you will go to Wayne County Jail. You understand?
Yes, Your Honor.
All right, you have your bond conditions, so we'll see you at your next court date.
Thank you, Your Honor.
Thank you, officer. He can, you can make arrangements so he can make a call for bail.
I hear you.
Thank you.
Thank you.
Have a good day.